Now, tragic news broke yesterday morning that South Africa's Olympic sprinter Oscar Pistorius was taken into police custody on Thursday, and his father confirmed that after allegedly shooting his girlfriend, having mistaken her for an intruder at his upscale home. Now, our thoughts and condolences do go out to the family of Riva Steenkamp, who died yesterday. Now, this morning in our studio, we have senior law faculty lecturer Kelly Phelps, who's here to talk about the relationship between homicide and the law and how exactly this might play out. Good morning. Great to have you with us here.
Good morning. Thank you.
Now, in my little knowledge of law, studying and having had a bit of BCom law in my studies, I understand that context is very important when you speak of legal matters. So, in self-defense, how does one define textbook definition self-defense?
Well, interestingly, before we define self-defense, it's necessary to just consider that term, because actually self-defense is a colloquial word,
Yes.
and lawyers would prefer the term private defense.
Okay.
And the reason for that is it more accurately depicts the broad range of circumstances that can fit under that legal defense. So that would comprise the definition. So a broad definition would be that a person is acting in private defense when they are the victim of an unlawful attack against either themselves or a third party or some other legally protected interest. So, for example, their property. And they then use force to try and repel that attack. And where that force causes some sort of harm, if they're acting in private defense, their behavior will not be considered unlawful. So it's quite a vague definition. And what has happened is the law has developed more precise conditions to attach to that definition to help give clarity and guidance about when we are or are not acting in private defense. So there are 3 conditions that relate to the attack, and 3 conditions that relate to the response to the attack.
Yeah.
In
order
order,
born from real-life situations that have obviously led the law to develop these.
Absolutely. So the conditions relating to the attack would be that there needs to be an unlawful attack against a legally protected interest, and that the attack needs to be either imminent or commenced.
Okay.
In terms of the response to the attack, it needs to be directed at the attacker themselves. It needs to be necessary in the circumstances. And essentially what necessary means is that there's no other means available in order to avoid the harm. And lastly, and very importantly, it needs to be a reasonable response to the attack.
A reasonable
response. And that, the courts have interpreted that essentially to comprise of 2 elements. The first is an element of proportionality, which means there needs to be some sort of reflective relationship between the seriousness or gravity of the initial attack and the seriousness or force used in order to repel that attack. The second element is that of a warning. So courts have generally required that the person trying to repel that unlawful attack issues some sort of warning to the person that they're about to use force on. So, for example, if I'm going to use a firearm to protect myself, the courts will usually require that I issue a warning shot before shooting a fatal shot at the person attacking me. But that is considered in the circumstances of each case. I
was about to ask whether it is circumstantial, because if you don't have a chance to do so, then obviously that it would then work out differently, right?
Absolutely. And the law, certainly in South Africa, the way the law is developed in South Africa, it doesn't require us to value someone else's life over our own. So if you were in a situation where it would not reasonably be possible to issue a warning without putting your life at immediate risk, a court arguably will not expect you to do that in that circumstance.
Now, we've spoken about a whole bunch of different aspects. There's the commencement, there's the imminence of the attack, there's the measure of proportionality. You've done a lot of case law as well. Give us a bit of a description of where a private defense situation could arise.
Okay, well, they're very clear examples where it arises, and that would not be a problematic case that comes before the court. So, for example, if I'm in my home and I'm sleeping and an intruder breaks into my home and I wake up to their hands around my neck, I won't be really expected to meet that checklist of conditions. I'll be able to retaliate immediately in order to save my life because a very serious threat has already commenced. The more difficult situations arise where it's not quite so clear-cut, and then these different conditions come into play in order to determine it. So, for example, there was a case in 2003 where a gentleman was hosting a dinner party, 2 of his guests were leaving, they were attacked as they were leaving, And he decided to go and pursue the attackers because he feared for the safety of his other guests.
Yes.
So he took a firearm with him and he went to go find the attackers. He encountered them and the attackers started walking towards him. And he did fire a warning shot and told them to stop, but they continued walking towards him. And at that point, he issued a volley of shots and ended up killing one of them and injuring the other one.
Yes.
Now, interestingly there, even though he had issued a warning, he was not acting in private defense. And the courts there placed emphasis on the fact that the attackers at that point were no longer armed, they were dressed in nothing but shorts, and it was quite clear that they didn't pose a very serious violent threat to him in that moment.
Wow.
So by issuing a volley of shots that would certainly have been fatal, that was not a proportionate response to the objective situation that he was in. Now, had he rather issued an incapacitating shot and, for example, aimed at someone's foot or someone's hand and
Yes.
tried to make them drop to the floor, then he would have been acting under private defense in that circumstance. Wow. So you can see, as you mentioned about context, it is very context specific, and it's a matter of fact on the facts and evidence of each individual case.
Wow. Well, thank you very, very much for your time and for all that insight, shedding some light on this very in-depth topic. Really appreciate it.
It's a pleasure, thank you.
Senior lecturer at the law faculty at UCT, Kelly Phelps, shedding some light on the issue of private defense, a very, very important issue that we're talking about this morning. Well, we'll be right back after this break, taking a look at what's happening in your headlines.